Good evening, everyone, or good afternoon. It gives me great pleasure to welcome you to our launch of two books, Company Directors, Principles of Law and Corporate Governance, second edition, and Corporate Law and Governance in the 21st Century, Essays in Honour of Professor Ian Ramsay. My name is Rosemary Langford. I'm Harold Ford Professor of Commercial Law here at Melbourne Law School and Director of the Corporate Law and Financial Regulation Program of Melbourne Centre for Commercial Law. So let me first say that Melbourne Law School acknowledges the Wurundjeri peoples of the Kulin Nations as the traditional owners of the lands on which the law school stands and pays respects to their elders, both past and present. So we're privileged to have the Chair of the Australian Securities and Investments Commission, Joe Longo, to launch the two books, followed by a panel of experts to discuss key issues in corporate law and governance. So what I'll do is briefly introduce our main speaker and panellists before passing to Joe to launch the books. And I do note that fuller bios were provided with the event details. So firstly, Joe Longo has been ASIC Chair since June 2021 and has over 38 years experience in corporate law, financial services, governance and regulation in Australia and overseas, having been Senior Advisor at Herbert Smith Freehills immediately prior to his appointment as ASIC Chair. Ian Ramsay AO is Redmond Barry Distinguished Professor Emeritus at Melbourne Law School and has published extensively on corporate law, corporate governance and financial regulation issues, with extensive experience as an expert consultant to government reviews and as a member of government advisory committees. Catherine Walter AM has a distinguished career in service to the Australian community in the corporate, government and not-for-profit sectors and has served on approximately 30 boards in the listed, unlisted and not-for-profit sectors in a wide range of industries. Diana Nicholson is a senior partner in the KWM Governance and Mergers and Acquisitions practice and leads KWM's financial services sector with experience in governance, securities laws and mergers and acquisitions. And last but not least, Andrew Godwin is Acting General Counsel at the Australian Law Reform Commission and a Principal Fellow here at Melbourne Law School, where he's an integral member of the Corporate Law and Financial Regulation Program of Melbourne Centre for Commercial Law and Honorary Associate Director of the Asian Law Centre. Okay, so I'm now going to hand to Joe to launch the books and then we'll have our panel discussion.
Thank you, Rosemary, for those opening remarks. It's an absolute honour to be here this evening to launch not one, which is always a bit of an achievement, but two books. So I think you're getting excellent value. One book, of course, was written by Professor Ian Ramsay himself, and the other written by a number of other people. And it's an absolute privilege to be here among such a distinguished company, and I'm looking forward to the panel discussion. Corporations are at the centre of our society, our community, our economy. Informed, thoughtful scholarship makes an important contribution to public debate and understanding. We live in very challenging times. One only has to look to the US, to Ukraine, to the Middle East. And I've been reading recently Martin Wolf's most recent book, The Crisis in Democratic Capitalism. He makes a number of points which I want to open with. The most important actors in the contemporary market economy are corporations. The company has been a staggeringly successful innovation, but it has also turned out, in Martin Wolf's words, to be something of a Faustian bargain. Wolf identifies a trend in modern capitalism characterised by the emergence of multinational corporations and regulated financial markets, and also of bigger, more intrusive states. Behind this trend has been a ceaseless debate over how society should be organised, and in particular, over the relationship between the markets and government, and also between companies and the rest of civil society. And of course, the two books that we are talking about this evening, and it's my pleasure to launch, go directly to these themes. I want to start with Ian's book. Now, for those of you who have read Ian's book, I direct you to the first sentence. It's a rather modest introduction to what is quite a significant publication. Some of you may have noticed it on the way in. It's quite formidable. I'll read the sentence out. This book deals with principles of law and governance as they relate to company directors. That's it. That is the modest, succinct introduction to this extraordinary piece of scholarship, and it says something about Ian's personality as well. To the point, clear, no nonsense. We all know Ian has already written extensively about the topic of directors' duties over the years, and this latest publication adds to a broad and expert body of work. Directors' duties, as set out in the law and how they operate in practice, have undergone a significant transformation in the last few decades, given the increased complexity of commercial structures and transactions and developments in technology, all points made in Ian's book. They remain a key area of enforcement focus for ASIC. Yes, we are still a law enforcement body, and I'm quite happy to be challenged about that by anyone at any time in any circumstances. And Ian devotes a big part of his book to the research that I'll come to in a moment. I was at an AIC dinner in Darwin last week, as you do, in an attempt to be helpful to the vast majority of Australia's company directors who manage small to medium-sized businesses. I offered some fundamental guidance to directors. I said you should ask yourself regularly, are you putting the company first? Do you have a continuous curiosity to understand all aspects of the company's core business and the risks associated with it? Are you challenging management to ensure your understanding is well-founded? And are you getting trusted professional advice? To which I could have said, oh, you could read Ian's book. You could read Ian's book. But I think my audience, who represent the vast majority of directors in our great country, we have 3.2 million registered companies in Australia, and the vast majority of them are run by ordinary men and women who are trying to cope. Now, of course, our discussion today, we will be flying at 300,000 feet above sea level, but I do want to remind everyone that the backbone of the economy is actually ordinary men and women. There are three aspects of Ian's book that I quickly want to sort of spend a moment on. It's a huge book, and I've just chosen three aspects out of my own indulgence. The first is the company as a social mechanism. Now, one of the more interesting things over the last 30 years or so is the competing conceptions of corporate governance, maximisation of shareholder wealth, stakeholder perspectives of corporate governance. And Ian does a terrific job in the opening part of his book, sort of reminding us of that debate and asking, as always, the right questions. This corporate governance debate is intrinsically linked to two important questions. For whom do directors govern? I often ask myself that question from an ASIC perspective. Who am I supposed to be there to be looking after? Do they govern for shareholders or for a broader range of stakeholders? Pretty fundamental stuff, and I'd say to everyone to have those questions at the back of your mind. Second thing I want to stress, which I've already mentioned, Ian has led or presided over many ASIC enforcement research studies on enforcement of directors' duties, including who brings litigation, the duties contravened, and the penalties imposed. I would note, as Ian does in several places, ASIC's high success rate over many years in this litigation. I would also note that Ian didn't do all this by himself. One of the great aspects of Ian as a person, as an academic, is that he's a great collaborator and mentor. And so when you look at this part of the book, you'll see, I see Dr. Bird's in the room and others, Elizabeth Boris and others. Ian is a very collaborative academic, and a lot of the research that he's done over, I have to say, 30 years, that's how I first got to know Ian in the mid-90s, has always been collaborative, and he's made a very significant contribution to our understanding of enforcement and the issues that arise. The third thing I want to raise is sort of like a personal favourite that I've been discussing with Ian, and it arises out of the duty to act with care and diligence. And I've sort of compendiously referred to it as reasonable reliance. Of particular interest is the degree to which directors may rely on the expertise and judgment of others. When does it become unreasonable to do so? When can directors be required to apply their own minds to often difficult questions? What degree of challenge can be expected? Now, there are a number of cases, probably the most notorious is Centro in more recent times, but there have been others. Healy is another one. We have an expectation that directors will understand the financial performance of their companies. And it's often said that they need to balance the foreseeable risk of harm to the company against potential benefits. But the reason I want to stress reasonable reliance to a group like yours, and indeed I take every opportunity to do so, is if one thing we can all say with moral certainty is that being a director of a company these days is not getting any easier. You know, we are looking at technology, at AI, at sustainable finance, disclosure standards, the proliferation, the number of times that gets raised with me, the proliferation of offences under the Corporations Act. And I haven't mentioned, you know, fair work and a whole range of issues that we expect directors to be on top of. So my message to the directors is they shouldn't be expected to do this all by themselves. I do expect them to make an effort. And secondly, whoever's advising them, whether it's the General Counsel, the Company Secretary or an external advisor, then I think there's a strong public interest in requiring them to do the right thing by directors. And how that dynamic plays out is a subject of one or two cases we're running at the moment. But we'll have to wait for the courts when they get around to hearing them to tell us what the answer is. The second book we're talking about this evening is, of course, the book that's been edited by Rosemary Langford, Essays in Honour of Professor Ramsay. What an enormous range of work this book represents. I have to tell you, it's a bit easier to get through, Ian. For reasons which will become apparent. Yeah. Just want you to know that as Sunday unfolded and I was trying to get on top of the book, I did have to reach for a decent bottle of red wine. Anyway, I'll put that to one side. But as the Honourable Kenneth Hayne notes in his foreword to the volume of essays, no collection can fully reflect the breadth and depth of Ian's work. I commend Professor Rosemary Langford for bringing together this collection of rich and thoughtful commentary written by a range of esteemed practitioners, mostly. Essay from me in there somewhere. Most practitioners, scholars and regulators have their favourite area of corporate law, and this collection will have something for most of us. So I'll quickly go through some of the topics because I can see there's a whole pile of those books sitting out there, and everyone should buy one before they go. I'll be making it my personal mission. The impact of ESG on regulation and governance. The fundamental duties that underpin much of our corporate environment, directors' duties of care and diligence. The sheer complexity and scope of corporate law involving normative standards, technology and how this is impacting, digital finance. All of these topics are the subject of essays. I was particularly intrigued by the chapter on directors' duties and artificial intelligence, and whether or not there may be now or in the future. I have to say I was a bit surprised by the thesis of this chapter. A potential obligation to directors to use AI if it is the best way of doing things. And of course, we're all worried about AI, but directors may very well be under an obligation to use AI. So I'm looking forward to hearing a bit more about that. The chapter that is candidly, and I think accurately, named The Failure of Corporate Law Reform in Australia does, on a more positive note, set out a range of potential areas that would benefit from holistic structural reform. And I just want to call out the last chapter of the book, which deals with causes and impacts of financial hardship in Australia. This is yet another echo of Ian's enormous influence on Australia's regulatory framework in relation to consumer protection. As we speak, one of his great pieces of work, he chaired the inquiry which has now led to the compensation scheme of last resort, which is finally operational, although I don't think they've announced a chair yet. I'll look at my fellow commissioner. So this collection really raises a whole range of topics. I do commend it to you. In conclusion, Ian's contribution extends beyond Australian legal education and the academy to the mentorship of academics and practitioners, the advancement of high professional standards, and the understanding of key areas of economic regulation. I'm honoured and delighted to launch these two books, and I commend them to you. And remember, they're available here. You know, they need to be purchased and read and reviewed, don't they? Yeah. Thank you.
Oh, thanks so much for those comments, Joe. Ian and I are both very grateful to you for launching both books. So now we're going to get into our panel discussion. And as Joe noted, there are a number of themes that permeate both of the books. One, of course, is directors' duties, particularly, well, the second book, at least, the duty of care and the duty to act in good faith in the interests of the company. Other themes are the impact of ESG issues on a number of areas, the impact of the COVID pandemic on corporate law, corporate governance, financial regulation, complexity and scope of corporate law legislation and governance, and the impact of technology. So now I'm going to turn to our expert panel and ask some questions of them in relation to each of these themes. So we'll give Joe a little bit of a rest at the start and yeah. Okay, so one of the themes of the book, particularly of Steve Carabas's chapter, is corporate engagement. And so, Kathy, I wondered if I could start with you and ask you, in a post-COVID world, do physical AGMs serve shareholder interests?
Thank you very much, Rosie. First up, can I say what a particular and singular treat it is to be here, Ian, in your honour. We inveigled Ian to join Clayton Utz back in the day when I was managing partner to help all the corporate lawyers really get corporate law right. And I think without a fault, you made sure we did that. So Ian, they were very happy times. He stood in the feet of Harold Ford, who'd previously been in that role, but it was a wonderful engagement and it's an absolute delight to be here. So I was preparing for your tricky question outside in the rain, Rosie, and I happened to have my digital copy of the Fin Review, which reprised the reflection of one of the shareholders at the Qantas AGM, because AGMs in a physical sense are elemental theatre, having sat through a few of them. Zooms are a thing, but they're not elemental theatre. And so this is a shareholder who held and holds 1,000 shares. Indulge me if I might read what he said. At last week's annual meeting of Qantas, Board Chairman Richard Goyder directed that my microphone be turned off during questions from the floor. My sin was that I questioned the morality of board decisions, the illegality of Qantas shedding 1,700 ground handling staff, the ACCC's prosecution of Qantas for allegedly selling 8,000 ghost flights, and Goyder's approval for Alan Joyce's $17 million share sale. What a trifecta. After 40 years as an investor, that Qantas meeting was the worst I have attended. It was carefully scripted with an excess of security staff and board members who looked ill at ease with their owners, the shareholders. What the board knew, but the audience was yet to learn, was that the remuneration report had been voted down by a stunning 83%. That result means that almost all shareholders, including the institutional holders of Qantas stock, have had enough of brand damage. Of the 178,000 owners in Qantas, just 160 shareholders control 80% of the company. That is holdings greater than $5 million. I am just one of those other 107,000 shareholders with fewer than 1,000 shares. Goyder, whom I like a lot, but anyway, I'm quoting the guy, Goyder's petulant silencing of me has tainted his reputation. The meeting was a miserable experience for the board, such that none, repeat none, of the members attended tea and sandwiches with their owners after the formalities. Goyder had stated that the board would spare 5 to 10 minutes to speak personally with shareholders. It never happened, the first time in my experience. You don't get that on Zoom. You know you're alive at a physical AGM. And everything that happens into an AGM has the total focus of the chairman of the various committees of the board, and as a director of many funds managers over the years and listed investment companies, your diary is very busy before AGMs with chairs of remuneration committees, nomination committees, audit committees, chair of the board, coming to you to just sort of assist you understand what it is that might be the business of the AGM. So insofar as one of the key duties of directors is to hold management account for the benefit of the shareholders. That stakeholder point is a good one, of course, but the AGM addresses a shareholder interest. The physical AGM has no parallel. Thank you, Rosie.
Thank you. I would differ though. I think scones are better at AGMs than sandwiches, but that's my personal favourite. Did anyone else want to comment on that, the issue of AGMs at all?
I just thought I'd perhaps make one comment, Kathy, which is it's really interesting, I think, through COVID, how quickly people adapted to the hybrid meeting. But what is interesting is that coming out, we're moving back to the physical meeting quite quickly. So Telstra, million shareholders, I think there was really very, very few online. It was really quite a small number and very few questions. Not that that's not a uniform experience, but there's a huge shift almost immediately back, because to be in the room, to be part of the debate is much more powerful than asking your question through a chat box, unless you're certain well-known semi-activists where you lodge your questions, then move to the next meeting. You possibly miss the answer to the questions, but then you come back with your next questions. And I don't wish to defame anyone, but that does happen. So I think just ready to reinforce your perspective, I think that's where we're back to.
And perhaps I would add too, I think I would agree with Kathy, but of course, if we go back to the middle of COVID, when companies were holding virtual AGMs, were required to, under changes to the Corporations Act and then Treasurer determinations and also assistance from ASIC, when you look at views by peak organisations on whether virtual AGMs should be permitted for the foreseeable future, key organisations were split. So, for example, the Governance Institute said, yes, we think that's absolutely the case. Companies should be free to have virtual AGMs for the foreseeable future. But of course, Shareholders Association, Council of Superannuation Investors said, no, not for listed companies. Those companies should be required to hold hybrid meetings. I remember reading some research coming out of the US, which I thought was pretty interesting, because although virtual AGMs clearly have a cost saving for companies, and that cost saving can be quite substantial, issues going to accountability, as Kathy's highlighted, are really quite important here. Some of the research coming out of the US in the early days of COVID compared a sample of S&P 500 companies that the year before COVID, 2019, of course, held in-person meetings, and then during COVID, held virtual meetings. And what that research showed was that when you compared the two meetings by the same companies, generally you had something like virtual meetings being 14% shorter than physical meetings. That part of the meeting devoted to activities of the company, update on company, was 40% shorter, and question time, management, directors answering questions, virtual meetings were 18% shorter in length. And the author concluded by saying, well, this evidence that she'd found tends to support the argument that virtual meetings end up conveying less information to shareholders than physical meetings. And you also have some concerns, I guess, also that have been expressed by some shareholders that with some virtual AGMs, although I do totally agree with Diana that companies have gotten much better at the technology, that sometimes with some companies, directors, managers aren't quite transparent on which questions they choose to answer. I think we have seen a little bit of that. But of course, we're due for a review of those changes that we're introducing to the Corporations Act. And I think it's really going to be important that review collects appropriate data on attendance and voting, because of course that their arguments in support of virtual and hybrid meetings, that you can increase accessibility, you can increase participation in those meetings, gets views of directors, company secretaries and others involved with virtual AGMs, and does a really good job of assessing whether virtual AGMs offer advantages or potential disadvantages to shareholders. So I think that review is going to be quite important. But I think at the end of the day, as Diana's indicated, many companies under shareholder pressure, I think, because some companies, of course, have gone to their shareholders with proposals to amend their constitution, which, as we know, is required to hold a virtual AGM, and that's been knocked back. Some companies have had success. Some companies have taken it to shareholders, and after consultation, they've withdrawn the proposal. So I think that review will be interesting. If it collects the right data, speaks to the right people who have experience in these, I think it'll provide a good roadmap going forward.
I think
Sorry, did you want to say
No,
something
no,
else?
I agree. I mean, I think the main thing is to make sure that the forum is one where people can have a discussion meaningfully. And I'm just not sure whether going forward, if you've got a few people online and the bulk of people present, that's the best formulation. So let's see what the research shows.
Oh, thank you. Well, Diana, I wondered if I could touch on, you mentioned shareholder activists, and I think we're seeing a rise of shareholder activism in Australia. I wondered what activists want and how they go about getting it.
So I should just declare that practitioners love a bit of activism. It's quite good fun. So I probably should be saying I'm colouring my thoughts a little bit here, but I certainly think that we have seen a rise in activism, and by which I mean not the sort of activism that we've had in the past in Australia of people requisitioning around climate and carbon type issues, but actually activism more along the lines that you see in the US. We're quite slow to that party. There's been very strong activism in the US for a long time, and yet we have a toolkit which is really very activist friendly when you think about it. We have a 2 strikes resolution, which people have used for a long time for performance. We've got great ability to nominate and remove directors, a little bit clunky, but not unfairly so. We've got great ability to requisition meetings, and we've got a regime where we have meetings, which people do advocate at. But I think what is also interesting here is that why finally are we getting to this point? And I think in part it is the rise of superannuation, their sophistication and their obligations to their members to actually exercise their powers appropriately. And that's certainly been a 5-10 year thing. It's not most recent. We've seen the rise of proxy advisors. They're a whole industry, and hopefully ASIC pays attention to them from time to time, Joe, but they are a very powerful cohort, and the superannuation funds for a long time really were just advised by proxy advisors. Now they are a very, very powerful cohort. And if you're a big company, and Kathy, maybe your perspective would be interesting to hear, if you're a big company, you get adequate time to explain yourself. If you're a smaller company, it's much more of a bun fight to get proxy advisor time. And yet you still may wish to sort of advocate for your issues and to make sure they're well understood. So I think those factors are interesting. The M&A market was very busy during COVID, which meant that, we did various pieces of work looking at how much do you have to get a board seat. That's really interesting that that's become such a powerful tool. And also you may not pay for it. You might have synthetic equity, which is quite interesting. And so what are those people after, Rosemary? Well, they may be after their own financial agenda. So it could be a pure financial play, could be a values piece, as we've seen in some of the carbon space. It could be a short-term versus a long-term view. And I think what is interesting is you're hearing people speak much more strongly. And that's all quite good fun, because as part of that, then there are a lot of the discussions that you don't see publicly around who the board should be. And I think really coming out of Hayne, in fact, when you think back to it, we had people speaking very clearly as to the performance of management. How do you change management? You make the board change management, because in the end, it is the most important thing a board does, is to get the management right. And to Joe's earlier point, how do you do that? You've got to go through the board to effectively do it. So I think certainly we're seeing a much more active market, and a little bit more sport, perhaps.
Oh, thank you. Well, I might turn now to our theme of technology, cyber and sustainability. And Joe, you touched on this earlier, but I wondered if you might like to elaborate on how emerging issues like climate reporting, sustainable finance, use of technology and AI are impacting the responsibilities of directors and boards.
Yeah, I think we need to step back here. I think for a lot of directors, and I include the big end of town, I think they're all a bit overwhelmed by the amount of change and the intensity of it. I sort of feel that myself, because I'm getting constantly briefed. I'm spending a lot of time, obviously, trying to understand these issues myself. But any one of these issues, take climate reporting. I mean, that's a vast new subject of great complexity. We have a real capability issue. Even entities that want to comply have to build systems, processes, technology. They need access to professional advice, which doesn't exist. Even as we speak, there's a debate going on about which the international standards, the S1 and S2 coming out of the ISSB are going to become Australian law. So there's a whole debate unfolding right now that Treasury are at the pointy end of. So I think the same I think can be said of AI. I mean, the AI has just sort of exploded onto the scene. It's obviously been there a long time, and there's a lot of interesting books have been written, and we haven't just sort of started thinking about AI this year. But I think the arrival of ChatGPT and other developments have just really thrust this issue onto people's agendas. And so I think that's there's just no easy answer to that. No one really knows where it's going to end up. And just going back to the technology theme, although today's events apparently had nothing to do with the cyber attack, apparently, was it
No, you're right about
Yeah.
that. I'm just doing a software update
Yeah.
as you do.
Yeah, so the you know, I can understand.
I'm not on your side here.
I can understand that. I've got lots of those stories back from my previous life about someone switched the wrong button off on the middle of the night on a Saturday morning and triggered this huge investigation, and all of it was human error. Just pushed the wrong button. But just going back to the technology theme, that whole cyber issue, I mean, that is, if we had nothing else to talk about, forget about AI, forget about sustainable finance, the whole cyber risk aspect and cyber resilience and all of the features of that issue, I mean, that just affects everybody. I know in my discussions of AICD, for example, you know, they're trying to come up, they've done some really good work trying to come up with some practical advice for company directors. And as I said in my remarks, it's easy to talk about the big end of town when you talk about company directors, which is fair enough. You know, it's interesting and they are a major part of our economy. But the fact of the matter is there are literally millions of individuals that are running businesses that are relying on third-party providers for data and all sorts of things. So I don't have too many answers there. I think that all we can do as a society and as a regulator and as a community is to be honest with ourselves about how difficult these challenges are. And to find ways of collaborating to deal with them. I suppose that's my only other message. I can't think of a single problem facing the regulators, business, company directors that doesn't involve some collaboration to solve properly. Because if you're going to rely on the courts, you know, for recovery of civil penalties, then you've well and truly lost the game.
Yeah. Oh, thank you. Well, Andrew, your chapter in corporate law and governance in the 21st century has already been mentioned in terms of AI, but in that chapter, you do mention that we're seeing a shift from governance of AI to governance with AI. So I wondered if you could explain what's meant by that shift and the implications it presents.
Very
and
happy.
then everyone will go and read your chapter.
Oh, thank you. Thanks for the plug, Joe.
I can commit, it's really interesting.
Well, I'm pleased that at least there are two people I've met tonight who've read my chapter, so I'm very grateful for that.
Multiple times.
ChatGPT has read it.
Well, so
And Miranda.
Rosemary and Ian, let me first congratulate both of you for the launch of the books this evening. As I said to Ian just before, we know to whom we should give credit or whom we should blame for bringing us together tonight, and that's you, Ian. So no doubts about that at all. So yes, Rosemary, as I was thinking about what I might say tonight, I thought how interesting it is that when we approach the regulation of technological innovation, we usually approach it with a high level of caution, which is appropriate. And I think by technology, I'm not just talking about algorithms and AI, I'm also talking about new ways of doing things, new systems, new ways of thinking. It's all part of what we describe as technological innovation, I think. And so what we tend to find is that after a period of hands-off regulation, as we've come to grips with this phenomenon, our focus shifts to reining it in and preventing it from causing harm. And finally, we reach the point where we embrace the technology and start to use it as a governance tool itself. And an example of hands-off regulation, I think, was the introduction of derivatives trading back in the 80s and 90s, when we really left all of that to private ordering, private contracts. And of course, when the global financial crisis came around and we realised how much harm these contracts were perceived to be doing, whether in fact they were just used incorrectly or what have you, I'm not sure. We then thought, well, we need to intervene and we need to do something about it. And we've seen this too with other developments, and that includes cryptocurrencies. We've also seen it with artificial intelligence. And part of the challenge, I think, is dealing with taxonomy, working out what they are and therefore how we should regulate them. And that's, I think, one of the key issues. So for derivatives, for example, the question that arose was, are they insurance contracts or are they gambling contracts? And the answer to that would then determine how they might be regulated. So what I explored in my chapter is whether we might reach the stage, or indeed whether we have already reached the stage where we need to be concerned not just about how artificial intelligence is used, namely the governance of artificial intelligence, but also about whether we have a duty to use artificial intelligence for governance purposes. And that's what I refer to as governance with artificial intelligence. And I examine all of this in the context of boards of directors and whether the statutory duty of care and diligence might be said to incorporate an obligation to use artificial intelligence in the appropriate circumstances. And what I did was I drew on a case that was decided 30 years ago in the US called Brain and Roth, which gave rise to what came colloquially to be called a duty to hedge. And it arose in relation to a case where the directors of a grain cooperative had failed to monitor and to utilise hedging contracts for the purpose of managing their foreign exchange exposure. And so what I did was to look at the insights that we could draw from that experience. And I suggested 3 factors that should be considered in determining whether a duty to use AI might arise. First, the sector in which the company operates. And I think it's more likely in professional services companies where you'll have this duty, so-called duty. Also, of course, the availability of expertise in the relevant area. And finally, the nature of the decisions that directors need to make. So not every decision might require the assistance of artificial intelligence. And we've seen this shift, I think, in regulation, Joe, where RegTech, for example, has brought with it the increasing use of technology for regulatory purposes. And so I think there are interesting parallels in that regard. But what all of this suggests, I think, is that technology can and usually does lead to better ways of doing things, often to the point where technologies represent the best or the most prudent ways of doing things, and law and regulation needs to adapt accordingly. I heard a comment recently about driverless cars, and I think this was a comment attributed to Professor Toby Walsh at UNSW. And the comment was to the effect that it won't be very long before driverless cars are considered to be much safer than human-driven cars. And our focus will switch from being concerned about the harm that driverless cars cause to being concerned about the harm that human-driven cars will continue to cause, as the tragic accident in Daylesford over the weekend demonstrated. So I think all of these issues are particularly relevant to directors as they contemplate how they might fulfill their duties. But also, I think, as you alluded to before, this question of cybersecurity is a very important area in which the use of AI and technology generally needs to be considered.
I think, Joe, you were wanting to comment on that.
Just 3 quick themes. I'd recommend Fool's Gold by Gillian Tett. She wrote a book about the very subject where Bernanke was talked out of regulating derivatives back in the late 90s, early 2000s. The rest is history. But the 3 key points, I think there's no issue, I think, facing any institution or regulator or company where systems, processes, technology isn't part of the solution. So if you look at you mentioned RegTech, I think one of the ways I like to think about things these days, I mean, at ASIC, there's not a single thing we're doing where I'm not having to build a new system or write some new program to be able to analyse, assess the data, and then put all that in a way that a human can actually deal with. So I think I absolutely agree with you. Technology I think impossible to imagine a world these days without technology. The second thing about AI, which I find fascinating, is this whole question of explainability. So I think if a director is going to embrace AI, whatever AI is, by whatever definition, I think there's still a fundamental duty to understand what the hell you're doing with it. And I think for a lot of people, there are some algorithms I think we can all accept AI is fairly straightforward. But these days, a lot of business models, the algorithms aren't that straightforward. And very often it's pretty hard to find someone in the company who can explain them to you. So I think that's something we need to, that I've spoken about publicly. I think that's a really interesting, crucial part of the AI story. The third thing that I've talked about is a so-called trilemma, and you've touched on it. And that is that when it comes to regulating technology, and you mentioned crypto, which always gets me wound up, the ASIC's not against innovation, but people often talk, and I have to say, people in the crypto sector in particular talk about innovation like it's a self-evident good, what that sector is up to. Well, with all due respect, I'm still waiting for the good to be manifested. Where's the medium of exchange? Where's the store of value? How's it actually helping consumers and investors, as opposed to being a triumph of faith over rational thinking? So the trilemma, in my view, is do we make lots of rules to protect consumers, and that has a chilling effect on innovation, or do we loosen things up and make it easy to innovate? Don't have too many rules in order to advance that. And then, of course, you increase the risk for consumers and investors. And that's, I thank Professor Pamela Hanrahan, who's probably not here today, for bringing to my attention some of the literature on that subject, which I find very helpful.
Kathy, did you want to comment?
Yes, Andrew, I don't know if your writing predated generative AI.
Interestingly, I don't know when generative AI came along, so I'm not sure whether it did predate it or not, but it certainly did occur at the beginning of this year. So before the latest round of debate occurred, I think, in relation to generative AI. So I think probably it would be correct to say that it came before.
Because I just wanted to add in another thought that generative artificial intelligence uses data we provide through our questions into the large language models, and it generates, as its name suggests, entirely novel solutions. So that when it first came out and about, we all thought with our data rooms, what a great idea to have all the due diligence material go through the generative AI and come back in a neat package. And the dilemma of that, of course, is that we've all signed non-disclosure agreements. And the second you put material in an unconstrained way into generative AI, you are disclosing it to the world, or the large language model world, and it is used for the solution of additional newly emerging issues. So there are means I discovered by referring to a close relative of mine who's in New York City and who knows about these things, whereby you sign up for a ChatGPT commercial arrangements, whereby you can, in some fashion, I didn't entirely believe his answer, I confess, you can create an obligation on the artificial intelligence operator to hold your material separately for you, which means it's not going to the large language model, which means it's not generally available, which means it hasn't been disclosed. But it's quite a leap of faith, quite frankly. But Andrew, next edition of your article, there you go, a footnote.
Thank you.
Thanks, Rosie.
It's already out of date.
Don't say that. We want people to buy the book.
I want to reassure you, as far as I'm concerned, it remains cutting edge.
That's a good plug.
Okay, well, turning to cybersecurity, that's been a key risk for some time, highlighted, I guess, by, well, I mentioned Optus, but I mean the Optus breach, the Medibank Latitude Optus type breaches that have really sort of shone a light on the impact of it. Diana, I wondered if I could ask you, how have you seen directors respond, and how do you think directors should respond, given that these issues sort of, I mean, they cut across a whole range of issues, including directors' duties and continuous disclosure?
So maybe I'll just focus on a few things, and I think the AICD, guidance is actually quite useful for directors. that probably sounds wrong, is very useful for directors. I don't mean that with surprise. So I think that is one thing, but what I thought I'd perhaps comment on is a couple of things that we've seen really as a surprise in relation to this. The first is the importance of culture. Having had the benefit of advising a couple of these people under duress, you need a culture where the organisation is all hands to the mill to fix the issue, to work out the issue, and to move forward looking after your customers or clients. If you don't have that fundamental culture and you don't have a boardroom that's cohesive, you are right on the back foot because you don't have time to fight. There is no time to fight. And so, you know, I've had the privilege of being in some of these board meetings. It was really an exceptional experience where you see directors all step forward and actually quite uplifting in the middle of a crisis. So I just would say that having a strong culture, and we've had this culture debate for some time, when you actually see it play like that and across the organisation, you can't ask whose fault it is. You have to ask what's actually gone wrong and how are we going to fix it. So I think that was one thing that was a core lesson for me. The other is having appropriate advisors. And I think what we're seeing now is proactively large corporations getting their advisor pool together. There are a limited number of competent advisors. And to your point, you know, Joe, knowing who they are, what they can do, how you control the dark web to find out what the hell is actually out there. All of those skill sets people are lining up. And again, that's a new industry that I think we hadn't seen so much come to play. The challenges of continuous disclosure for listed entities, just enormous, absolutely enormous, because you do not know in any given moment what the state of play is. And so you're trying to use caveated language, but be transparent and own the issue. It's a really tough continuous disclosure issue, I think, for directors. And I think the fourth issue really to call out at a high level is just the complexity of who you're dealing with. You know, ASIC wants to know what you're doing. If you're regulated by APRA, they're absolutely all over you. The Privacy Commission is there. The federal government's there. The AFP are there. They've learned, they started a long way back because they hadn't dealt with corporations. They're used to dealing with sort of different scenarios. You deal with really interesting issues, very, very interesting issue around whether duress can apply to decisions to breach law for sanctions. It's very interesting work on that. It's completely relevant to most people, but very interesting. And so those that just dealing with that complexity means you need a communications team that's really elevated. And because they have to be able to coordinate that, your messages must be consistent. And managing that at speed is very difficult. I think the other big lesson for directors was making sure you divide and conquer in the sense that you need people to run the business. The actual business must move forward or you will have nothing left. And actually thinking that issue ahead of time was something that I don't think I think they were surprised by, but moved very quickly to do. I think the issue that people will take up is what data do I actually need to retain? And for a number of the organisations where I'm a director, we've actually looked at that. And curiously, often you'll find with your legacy systems, you simply can't excise old data. And it's just because they're old and clunky and it just doesn't quite work like that. But understanding that as an issue is also something that I think directors are now trying to get their heads around. Boards, I think, are challenged by having appropriate directors, but all directors, I think, are learning. Kathy, you would probably say that, people are learning on the job, but getting someone with appropriate expertise is quite tricky because the world is changing so fast. And so I think, that's probably at the higher level that I think that just having those issues front of mind, having a strategy, practicing, all large corporations, of course, have business continuity programs, but actually running cyber scenarios, which they are now all doing. But again, that's time, and it's time when directors, really where you started, where directors have got so much to do, including run the core business. But this is just an integral part of it. So there are just a couple of thoughts that come out of rather than the step-by-step what you should do with your plan.
Thank you. Well, I'd like to talk to directors, turn to directors' duties, and who better to ask than Ian Ramsay. And I would like to focus on section 180 of the Corporations Act. So Ian, I'd like to, 180 is of course, I guess you'd say some of ASIC's most noteworthy and sometimes controversial litigation has been based on alleged contraventions of section 180. Which of course is the duty of care and diligence owed by directors and officers. So I wondered if you could distill for us what are some of the current and emerging issues associated with the duty of care.
Thanks, Rosie. Very happy to chat for a few minutes about the statutory duty of care in section 180. Just having written 1,200 pages on directors' duties, but now where's Robert? There's Robert. Robert picked up the book next door at the publisher stand and expressed disappointment. And the disappointment, he said, was 1,200 pages, Ian. As a director, I need a pithy summary. And I said to him, well, you can't blame me, Robert. You can blame the courts, you can blame Parliament, but you can't possibly blame me for it. Now, I have to convince Robert to buy the book. He typically relies on external counsel. So I've got my work cut out for me tonight to see if I can talk Robert into buying a copy of the book. But maybe just a handful of issues on section 180. And I guess the first one would be increasing use of section 180 by ASIC and increasing importance of section 180. So when I started practicing the law back in the 1980s and also in the late 80s started teaching corporate law, you would pretty quickly deal with section 180. You would spend a lot more time on other directors' duties. Well, the world has been transformed, and it's been transformed largely because of ASIC. Largely because of ASIC's use of section 180 of the Corporations Act. After all, it was only a few weeks ago that ASIC issues a media release saying that it'll sue 5 former directors and officers of the UPLA group, formerly the Aboriginal Community Benefit Fund, for allegedly mis-selling of funeral insurance. Really big issue. This is only one piece of ASIC's litigation, but interestingly, this piece of the litigation is a section 180 case. Quite a few announcements this current year of ASIC using section 180, but of course most notably was only December of last year when in front page news ASIC announced that it would be suing 11 current and former directors and officers of the Star Entertainment Group, which as we know runs multiple casinos across the country, again for alleged contraventions of section 180, this time in the context, of course, of arguing that the board of directors and certain corporate officers downplayed money laundering risks. When we look at the research that I and in collaboration with others have done over a number of years, it is absolutely true that ASIC is the main litigant on section 180 of the Corporations Act. One study I did, when you looked at all directors' duties cases over a number of years brought by ASIC or the CDPP, so it covered all directors' duties cases, when you just looked at the civil penalty directors' duties cases, and there's quite a few directors' duties that are subject to civil penalties, 40% of the cases brought by ASIC were section 180 cases. And then Ben Saunders and I did a subsequent study just focused on section 180 that really brought home some interesting findings, basically showing things such as ASIC is increasing its use of section 180. It's using it in new ways. By that I mean applying it to new circumstances. It has a very high success rate, 80% in its litigation. Now, I know some people say, and we hear this in Senate inquiries, oh, ASIC has a high success rate. It shows they're picking the easy cases. No one who's involved in directors' duties litigation would imagine or think for a second that directors' duties litigation is easy stuff. and that ASIC chooses it because it'll have an easy win. We just know that some of the most hard-fought litigation is directors' duties cases. And why not? Because defendants are actually very well resourced, their reputations are at risk, and D&O insurance is sitting in the back pocket. So that all sometimes leads to litigation that will go for many, many years. Just ask my former co-author, Dr. Robert Austin, who worked on OneTel for a decade as a judge of the New South Wales Supreme Court. So this litigation is hard fought, applying in new circumstances, high success rate. The sanction or remedy that ASIC mostly seeks and is ordered by the courts is management disqualification orders, which we know have a public interest side to them, because ASIC is seeking to take someone from out of the picture. So there's a strong public interest element in this litigation brought by ASIC also. So at the end of the day, when we look at Section 180, what we're seeing is a section that is increasingly important, and that is largely because ASIC has used it so successfully over many, many years. And its use of Section 180 is increasing. Ben Saunders and I looked at 25 years of Section 180 cases brought by ASIC and its predecessor. We looked at 25 years, but almost 60% of the cases were brought in the last 10 years. So that's just some information or some data that tells us that Section 180 has assumed increasing importance in recent years. But a second issue I'd also touch on is the impact of some ASIC Section 180 litigation on corporate governance standards. Now, I think it's fair to say that most ASIC litigation in the director's duties area will typically just have implications for the defendants. But when we turn to Section 180, it's absolutely true that some, not all, but some of this litigation will actually have broad ranging implications for other companies. Joe, in his very generous launching of the two books, mentioned, for example, the ASIC and Healy litigation here in Melbourne in the federal court, which of course was focused upon directors' understanding of financial statements, and in particular, the need for directors to understand current and non-current classification of assets and liabilities. So lots of things happened after that judgment came down. But from my perspective, and I think from directors' perspective, one important development was the ASX Corporate Governance Council, in what was then its third edition, introducing a new recommendation, 2.6, on the need for directors to receive appropriate support from the companies of which they're directors to skill up or maintain skills on fulfilling their duties and obligations. And the commentary refers specifically to the importance of directors being able to understand financial statements, and moreover, the commentary specifically refers to ASIC and Healy. It seems to me that's one example, but you could point to others. And as I say, this is not all ASIC Section 180 litigation, but examples where some of this litigation has the potential to impact upon governance standards in a wide range of boardrooms across the country. Again, I just put that forward as showing how, in fact, if you looked at a corporate law book 20 or 30 years ago, Section 180 wouldn't receive much attention. Now, Section 180 must understandably receive quite a great deal of attention. If I've got 1 or 2 more minutes, just touch on a third issue, because this issue is debated quite extensively, concern with ASIC Section 180 litigation and non-executive directors. So there is a concern among some commentators who say that some of this litigation operates unfairly, and it operates unfairly in the context of non-executive directors. Why? Because non-executive directors shouldn't be held accountable for reasons to do with the fact that they're part-time, they're not involved in management, and in particular, they should not be held accountable for management failures. So when those arguments are made, you need to unpack them a little bit. And I might just make a couple of observations on this. The first observation is that the evidence is pretty clear that the bulk of ASIC Section 180 litigation is not against non-executive directors. The vast bulk of it is against those who occupy executive positions, either executive director positions or officer positions. So we need to start with the working assumption, if you like, that ASIC's reasonably or pretty, perhaps even highly selective about when it, among the defendants, it has litigation against non-executive directors. But now that's not to say that when that litigation is brought, it's not very, it's certainly notable. And ASIC and Healy, James Hardy litigation, and of course, most notably now, we wait to see what will happen in the Star litigation.
You're waiting a while.
Yes. Well, I think that whatever the court decides on that will be widely read. But there is one other, I'll conclude with this.
Probably be hiking in the mountains.
We're not sure you'll be, Joe, but I'll be reading that judgment avidly. It just shows how I spend my time, really. Thinking, will there be another edition? Can't wait for a new federal court decision, to come out. But the courts here actually can be quite helpful to non-executive directors. A case only a couple of years old, DSHE Holdings. Now, it's not an ASIC case at all. It's a case involving a company that was insolvent, so it's private litigation. The company was famously known as Dick Smith. But of course, their problem was that they were purchasing stock that was very difficult to sell. And it turned out that they were purchasing this stock that was very difficult to sell because of a rebate system that they employed or adopted within the company. And so in this litigation, the defendants were two key executives and the non-executive directors. The litigation, private litigation brought against the executives, was successful. So both the CEO and the CFO were found to have breached Section 180 of the Corporations Act. But the court said and held that all of the actions against the non-executive directors failed. And they failed for a number of reasons, including the plaintiffs just not properly documenting the different responsibilities of executive and non-executive directors. But very importantly, it seems to me, in terms of providing roadmaps for non-executive directors, the court said, well, let's look at the evidence here. So here is a company in serious strife. After all, it's buying a lot of stock that it cannot sell. But the non-executive directors asked questions of management. They received plausible answers from management, and they had no reason to believe that the management of the company wasn't dealing adequately with this significant problem. Now, it turned out, of course, that management was not dealing significantly with the problem because the two most senior executives were found to have contravened Section 180. But the courts don't look back with 20/20 hindsight on this. They look at the time of the actual board meeting. And it seems to me this case provides some comfort for non-executive directors who do read instances of non-executive directors who have been found to have contravened Section 180, when they are in a situation where their company is confronting a significant issue, and there might be the prospect of ASIC bringing Section 180 litigation, or worst case, another scenario, perhaps an insolvency practitioner stepping in the feet of the company and bringing litigation. But the evidence shows that the directors asked the appropriate questions of management. They considered those responses of management. They asked further questions as need be, and they weren't put on notice. They weren't put on notice when they received those plausible answers. They weren't put on notice of anything that showed that management was not dealing adequately at the time with this significant issue confronting the company. Thank you, Rosemary.
It's really good.
Thank you, Ian. Are you wanting to comment?
No, I want to tell him it's really good.
There we go.
Probably no surprise that it's really good. But I'm actually very plain with my students. I say ASIC loves Section 180, so I put it out there. And one of the things I tell my students to do when they're looking at a Section 180 problem is to look at whether there's been any reliance or delegation. Now, Joe, you touched on that in your very generous launch comments. But I just wondered if I could probe those comments a little bit further to ask, how do you suggest that directors can ensure they've not abrogated their duties by relying on management?
Well, I think Ian's comments were masterful. That's very hard to improve upon, but I'll do my best. The couple of points I'll make. First is ASIC loves lots of sections in the corporation. Section 180 has one virtue, though, that I always remind people of, and that is you can read it. Have you noticed that Section 180 is made up of several sentences that aren't too long, that are in the English language, and you can actually read, and company directors can read? I regret to say that a lot of the Corporations Act remains entirely indigestible, but not Section 180. That's my first point. The second one, as far as reasonable reliance goes, I mean, Ian and I have talked about this a lot. I mean, to me, it really goes to the heart of being a director of a company these days, because there's a real tension between what we expect of company directors and what a knowledge of the business. I mean, I have actually read your book, a lot of it, and Jonathan Parker in Reed Bearings in 1999, directors have, both collectively and individually, a continuing duty to acquire and maintain a sufficient knowledge and understanding of the company's business to enable them to discharge their duties. And it's my continuous curiosity thing that I mentioned in Darwin last week. So I think it has to start with the directors. I mean, they have to, particularly if they're a director of a big institution, you just can't take on that role unless you're prepared to do the work. And even in the time of Middleton's judgment in Centro, I think in that case the judge said, "Well, get over it. You've got 500 or 600 pages to read them. Make the effort." So I think I think it has to start with the directors. Now, having said that, I think my earlier remarks should also confirm that you just can't do that job alone. And I think this is where the reliance concept becomes really, I think, quite profound. And that is where we have to rely on general counsels, company secretaries, chief financial officers, other senior experts in the business, and provided the directors satisfy themselves, within reason, that they've hired. I think Ian's already made these points in the Dick Smith situation. If you think you're dealing with competent people and haven't let you down in the past, then I think you're entitled to rely on their expertise, particularly if it's expertise that you can't be reasonably expected to have. Now, if the core business of the company, that to say is running a casino, but a bit change the example. But if the core business of the company, I'll go back to the old favours of manufacturing widgets, well, then you ought to understand how that works. You need to understand how those widgets are made, and what goes into them, and how you account for them, and whether you're making a loss or a profit, and what are the foreseeable risks of making those widgets are, and what are the benefits to the company. To me, that's all pretty basic stuff, and there's nothing revolutionary in it. But directors have got to be focused on that. And once they've satisfied themselves, they understand the business, then they need help. I don't expect them to do it by themselves. So this reliance aspect, I think, is something that needs to be tested more in the coming years. We mentioned AI before, sustainable finance, other things. I mean, I don't think it's reasonable to expect a director to be across all that. Maybe collectively, but they can't do it alone. So that, to me, that's why this is important in corporate governance. We have to have some relatively well understood guardrails around what do we expect of directors and what do we expect of the people that are advising them internally and externally. If we don't get that dynamic right, things are just going to go pear-shaped, and that's not in the public interest.
Well, thank you. Well, Diana, you mentioned culture earlier, and Kathy, I just wanted to ask you, has culture in a practical sense taken a back seat to what we might call mechanistic corporate law and governance compliance? So I'm wondering how a part-time board can create the time and climate in the boardroom most conducive to heading off liability for directors and executives, and also how directors satisfy themselves that that culture is driven through the organisation. Now, if you're like me, you won't be able to remember the first part of that question. So let me know if you want me to repeat it.
No, that's fine. I was listening to Joe and thinking about the question you might ask me, Rosie. So much turns, whenever I'm chairing an enterprise, on the quality of the papers. Because to John Middleton's point, if there were 600 pages, you've got to be like Ian Ramsay here and a few others to absorb 600 pages for a board meeting, unless there's only one per year. So by and large, the most complex ideas can be reduced to the things that really matter, that are going to make you go broke, or that are going to sort of kill your workers, or you're going to sort of put terrible things in the ocean. And so in a cultural sense, I've always regarded the lawyer's skill of asking questions and watching the way people feel when they're trying to answer them is one of the key things you bring to the engagement. And their consistency in answering, or where they're suddenly stressed and they're giving too much detail or too little detail, or a whole bunch of things. So that culture of being entitled to ask questions in a polite enough way to start with, and then, you know, see how it goes, is a critical thing that a director can bring. But the quality of the papers, I reckon if you looked at some of your Section 180 papers, board papers, don't even bother looking at the people. If they're incomprehensible, you've got the guys, because they shouldn't be incomprehensible. Life is complex. AI is horribly complex. The algorithms that lie behind these things are, for anyone in the room who doesn't have a PhD from Berkeley in statistics, probably beyond us. But there are ways that they can be expressed that make sense, and in a way that brings out the inherent risk. If I am wrong in this, these are the consequences. So that aspect of culture, you had a whole bunch of questions. I agree that it was complicated, but the mechanistic stuff should be done by the company secretary and the general counsel, and there should be programs that you can interrogate as to the way in which they've described the acts that impact on the company, and there's a mechanism that seems to make sense, and you trial a few things just by one-off examples to see if it's got integrity. But the key culture you bring as a non-executive director is contention, not accepting the obvious answer, persistence, curiosity. Have those and you've got a chance. So that's an answer.
They do use the word curiosity.
Yes, it was in your paper, wasn't it?
I thought you used it independently.
I was pitching to the audience.
All right, well, Joe, I will give you a break soon, but not quite yet.
I thought I'd sung for my non-existent supper.
Quite mean, if you like.
So this I mean, it comes back to some of the things you've touched on already, but do you think directors should be subject matter experts or good at asking the right questions of management? And I think we've already answered that.
Well, it's a bit of both, isn't it? I mean, this goes back to some of these questions have been with us forever. I think part of the answer to that is, what does a functioning board look like? You know, who you need a functioning chair that can bring people together, draw out a discussion, raise the right issues. And so I think there's a part of the answer to that question lies, and that there's no universal formula, obviously. A lot depends on the business and the culture and everything else. But to me, you've got to look at the board as a whole, and do you have the right mix of, frankly, personalities, intellect and expertise, and they can work together. I think the point's already been made very powerfully that if you've got a board that can't work together, first crisis that comes along, things aren't going to go well. So I think a board's got to work as a team. The second thing is, I think there is an element where this is the old generalist versus specialist debate. I think as the years go by, we sort of still need both. You know, we need some people on the board who, by virtue of their intellect, their experience, their judgment, their personality, they're just good at asking questions, and they're good at listening and bringing people together. And a good chair, I think, does all those things, but so can a director. But given particularly for the larger corporation, given the challenges that they're facing, and these topics have all come up already today, sustainable finance, AI, various other topics, then you're going to need some expertise on the board. And frankly, it's not enough, and I sort of choke as I say, it's not enough to say, I don't know anything about mathematics, science or technology. That's what I'm paying someone to do. Now that might be okay, but I think you need to have enough sympathy. Like I've been carrying around the chief scientist's generative AI report, March 2023. It's really excellent. Yeah. Genevieve Bell wrote it with some colleagues. By the way, the ASIC forum is in 10 days, and Genevieve Bell is the after dinner speaker. She's going to be brilliant. So be there.
Are you
Um,
selling tickets to that?
I can make that happen. I can make that happen.
Buy the book.
Well, there are actually lots of books on AI, but the point I'm making there is, look, I don't pretend to be an AI expert. But to do my job, I've got to have some idea.
Yeah.
You know, I've got to have some idea of what the key concepts are about.
Yeah.
And secondly, as someone pointed out earlier, I've got to have enough nous to be able to figure out in the general community and market, who can I speak to, who can help me understand this. And secondly, I've got to do some work. I've got to read and ask questions. So I think I don't mean to be flippant, but I think it's a combination of those things that lead to being a successful director. And I can't really add to the excellent points you made and Ian made.
Did anyone else want to comment
Yeah.
on that? Kathy, did you want to make any comments on subject matter experts or asking the right questions? I think you've already covered it.
Yeah, I've done pretty well on that, I think. Yeah.
All right,
Just a
so
bit of self-measurement.
Andrew, you've been sitting very patiently at the end there. I think it's time for a question for you. So you've done a lot of thinking around regulation and how to achieve a balance between innovation and regulation, which we've already touched on. And obviously that's becoming more challenging with technological innovation. So I wondered if you might give us your thoughts on that balance and how you think those issues play out in corporate law and governance.
Sure. Well, I think one of the challenges, as we noted before, is the taxonomical challenges of working out what something is before we work out how we might regulate it. And I think all of these challenges, particularly with the advent of technology, are leading to greater emphasis on principles, greater emphasis on objectives and outcomes, and a move away from regulating by reference to labels in terms of the type of product or the type of transaction that's the subject of regulation. And this has become particularly challenging in the context of crypto assets, and Joe alluded to that before. And that's because it is difficult to classify it for regulatory purposes. And that's largely because the function or use to which a crypto asset can be put really depends on the holder and what they do with the crypto
code,
asset,
right?
and the computer guy, yes. And that leads to another issue, and that is that it's very difficult to know on whom we should pin responsibility if something goes wrong, if the algorithm isn't working in the way in which it was intended. And so what we're seeing now, I think, is a move towards regulating the parties that provide the services in connection with these technological innovations. And we've seen, for example, the recent Treasury consultation paper on regulating digital asset platforms. And so we're seeing the incorporation of standards to regulate custodians, exchanges, and other secondary service providers, and regulating them more by reference to principles and outcomes than by reference to what they actually do. And I think, and this ties in with what was said before about the need to avoid over-reliance on detail. I think we need to try to avoid the tendency or the inclination to think that the more detail there is, the easier it'll be to work out how to regulate or how to comply with the regulation. And of course, the regulated community says, we want detail, we want to know how to comply. You tell us how to comply and we'll do so. But it does tend to take ownership of the outcome away from them. And so I see this, for example, in the debate around the duty to act in the best interests of clients in Chapter 7. And that's an example of the provision that initially was based on a simple provision, a principle in much the same way as Section 180. And that is to act in the best interests of the client. But over time, of course, it became increasingly prescriptive. We had the safe harbour and issues around how that should be interpreted and applied. And so, not surprisingly, the Levy report comes out with a recommendation that the best interest duty be replaced with a duty to give good advice. And so you can see how there's a focus on outcomes over perhaps the more process-oriented approach that we've had to date. Now, of course, the government has said, well, maybe we keep the duty to act in the best interest, but we finesse it in a way that makes sense. In the UK, they did debate the question, should they adopt our model of the duty to act in the best interest, or should they adopt something else? They actually adopted something else in the form of a consumer duty, which includes a principle that requires firms to act to deliver good outcomes for retail customers. So there is a move towards increasing focus on outcomes. And as part of the current ALRC inquiry into the simplification of corporations and financial services law, and this is another example, we've proposed that the requirement for disclosure documents to be worded and presented in a clear, concise and effective manner should be amended to require that disclosure documents also be worded and presented in a way that promotes understanding of the information. And so accordingly, we're suggesting a greater focus on outcomes. Now, I know that ASIC has had some reservations about this, partly because of the concerns around how that sort of standard might be enforced. But our focus very much is on clarifying how it should be interpreted and enforced, as distinct from introducing something new. I think this could be introduced to Chapter 60 disclosure as well, but I'll put that aside for the time being because our focus at the ALRC has been on financial products. So greater clarity around objectives, outcomes. We've seen this, for example, with the Parliamentary Joint Committee report on corporate insolvency and the call for greater clarity around objectives of insolvency law. And so I think, to answer your question, Rosemary, in order to achieve a greater balance, I think we need to have a better idea about legislative design. We need also, I think, to strike the right balance between rules, principles, and outcomes. We need to reduce complexity to the extent possible. In an article that Rosemary and I co-authored that's about to be published and hasn't yet gone out of date, we looked at this relationship between complexity, coherence, and ultimately ease of compliance. The saying that everything should be made as simple as possible, but not simpler, I think could be applied in reverse. Namely, things should be complex only to the extent that they need to be, and no more so. So I think we need to focus on managing complexity and avoiding unnecessary complexity, and that's very much a key driver behind the forthcoming release of the final report that we've been waiting 3 years for by the ALRC of the inquiry into simplifying corporations and financial services legislation. So that's a plug from me for the ALRC.
Anyone else want to do a plug?
And you don't need to, you don't need, and so you don't need to worry about where the copies will be available. It'll appear in electronic form. So.
Well, thank you. Well, complexity is certainly a theme that lots of us have been thinking about. I wondered if any other members of the panel would like to comment on complexity generally or the challenges faced. Joe, you might like to comment on complexity or perhaps complexity in relation to ESG. Does anyone have any comments they'd like to make about complexity? It's a very broad question.
Oh, it's the enemy of efficient regulation, I can tell you that much. Again, Ian has made a contribution. I always remember you wrote some material in the early 90s calling out Australia's love affair with complexity. And here we are in 2023 and we've just made it worse. So I don't think there's any answer to it. I think something Andrew said, which I find helpful, there's good complexity and there's bad complexity. And so I think it's a bit naive to think that there's some kinds of regulation and what we need to achieve in our community that doesn't require some complexity. And so if you look at market infrastructure rules, you know, how our markets should operate, what we expect of wholesale, in the wholesale markets, there's a lot of prescription there. It's quite complex, but it actually serves a real purpose because those rules actually do help us trade complex products in a safe, efficient manner. You can say, oh, it's bloody complicated. No one reads it. But the people that need to read it and understand it, they do. And we just take for granted a well-functioning market. And then there's bad complexity. And I think Chapter 7's bad complexity. I mean, it's just disgraceful. Mm. And it started in 2001 with the Financial Services Reform Act. The last time I was a lawyer, I actually read it all. And the creation of all those strict liability offences, just the length of the legislation, it just got worse. But I don't have an easy answer to it. I think the work the ALRC has done has been really, really helpful and excellent. But whether we're going to be able to translate that politically into legislation that is going to make the Corporations Act, more effective and easier to read, and all the things that practitioners and academics and users would like to see, I wouldn't be holding my breath.
I guess one good thing about complexity is it gives academics like me and Andrew something to write about, just to look on the bright side.
Yeah, but it often leaves commentators and parliamentary inquiries and politicians and those they listen to. It just doesn't make my job any easier because no one's prepared to do the work, to actually read, understand, and really step back and say, well, you should have done this, you should have done that. But very often it displays a superficial knowledge and understanding of the issues. But that's fine. That's fine.
Well, did you want to comment, Diana?
I just had sort of two quick thoughts. One is, and maybe I'm taking false comfort from some of this, but Joe mentioned the layering that exists for directors and the overlay of whether it's OH&S, not
right.
duty care or anything else. Maybe there's a role for sort of substantive cut through that could be quite encouraging. I think it's never going to happen, but you never know. It was quite a hopeful thought, Andrew, for a moment. And I think the other thing is just to take out of, again, as we move to the financial accountability regime where the accountable persons have to basically take steps to ensure compliance with a full range of financial services legislation, which they will not have read. Because, as you say, how could one understand Chapter 7 anyway? So I think there that ties nicely into the model of what you need to have a systems process, competent people, but you still need to know enough to challenge them,
right.
to know that those are actually addressing the risks. So I think that finding that balance of knowing enough and understanding the systems and processes and whether they can really hold, as well as testing the capability of your people more deeply than just the person who appears in the board regime.
I should hasten to say, I stressed this last week. I mean, as a regulator, of course, I place an enormous weight on good faith, on honesty, on good intent. I mean, if people are making a reasonable effort and making reason, I know that's begging the question, but I think that a lot of the time that gets you through. Very often when things go really wrong, it's really quite shocking how little people did that and you say, gee, is that all you did? Then of course regulator is going to be interested. But I think take the work, I haven't tried to read this, but the workplace relations reforms of the government, I'm told they're 500-600 pages of material to get through. And that's the humble subject of regulating the employer-employee relationship. And that's another area in Australian law. They're just changing that all the time. It just gets tinkered with continuously. That's just one example. Yeah.
Oh, thank you. Well, rather than ask another question, I think that might be all we have time for. I'm afraid one of us needs to get to the airport to fly to Germany, but I'd just really like to thank all of you. So thank you, Joe, Kathy, Ian, Diana and Andrew for those fascinating insights. We do have a gift for you that Avril will give you, but thank you all for attending as well. So perhaps we could give our panelists